Usually when you think about a crime scene, there is this, I don't know, this underlying expectation of obvious malice.
Right, yeah, like a broken window or a forced safe or something.
Exactly.
Yeah.
Maybe a weapon. The evidence of wrongdoing is loud, it's intentional, and usually pretty cinematic.
Yeah, it's driven by a clear motive, right. And you are basically looking for the person who actively decided to cause harm.
But then you step into the aftermath of a workplace tragedy, and that entire paradigm just completely shifts.
Yeah.
We are looking at a landscape where the weapon might just be, well, a missing signature on a piece of paper.
Yeah, or a skipped meeting.
Right. And the crime is simply a lack of imagination about what could go wrong. So, welcome to the deep dive. To you, the learner, we are so glad you are joining us today.
We really are.
Because our mission today is to step past that yellow caution tape and really explore the grim, high-stakes reality of post-incident health and safety investigations.
It's a heavy topic, but so important.
It is. We are looking closely at how the Health and Safety at Work Act of 1974 is applied when the literal worst-case scenario actually happens.
Yeah, we are dissecting the exact moments that duty holders fail. We're tracing that legal chain all the way from a chaotic site inspection right up to, well, a formal criminal prosecution.
Because when a workplace tragedy occurs, a clock starts ticking on a legal battle that can completely dismantle a negligent business.
Oh, absolutely. And when you look at actual investigations and regulatory actions, I mean, it is not just dry bureaucracy.
Not at all.
You see these stark warning diamonds plastered everywhere, symbols for explosives, toxic gases, biohazards, asbestos.
Right, the stuff that screams for attention.
Exactly. But the real danger, the kind that actually catches companies out, is often hiding in mundane negligence.
So take us to that initial moment. Let's say an inspector arrives on a site immediately following a major incident. How do they even establish control over what is, presumably, a totally chaotic, panicked scene?
Well, the defining characteristic of that arrival is the immediate, overriding authority the law grants them. This is under Section 20 of the Act.
Okay, Section 20.
Yeah. An inspector walking onto a site isn't there to just passively take notes or offer friendly suggestions. They have the power to instantly paralyze an operation.
Wow, paralyze it, like shut it down completely.
Instantly. They can isolate machinery, they can seize digital logs to prevent anyone from tampering with crucial evidence, and they can issue what is known as a prohibition notice.
Let's ground that in reality for a second, because there is a strikingly vivid example in the regulatory records we've been examining.
Oh, I know the one you're talking about.
Right, an inspector walks into a facility and spots employees using these portable A-frame ladders to retrieve and store heavy tires up at height.
Yeah, which is incredibly dangerous.
And they don't just, pull a manager aside for a quiet word. They issue a prohibition notice immediately. They halt that specific operation right then and there.
Because the inspector identifies that the conditions leading to a potential fall are active. They're present right now. So a prohibition notice isn't just like a pause button.
What is it then?
It operates more like freezing a crime scene in amber. The operation is paralyzed to prevent serious personal injury.
Wow.
And the psychological impact of that is massive on a site, because the inspector is actually required by law to ensure the workforce understands the danger.
Which means they don't just hand the paperwork to the site director and quietly leave.
No, not at all.
They physically leave a copy of that prohibition notice on the premises for all the employees to see. So it's basically like a referee blowing a whistle, throwing a red card that shuts down the entire game, and then making sure the whole stadium knows exactly why.
That is a perfect analogy. It acts as a very public quarantine sign for the entire workforce. It completely strips away any illusion that management has the situation under control.
Well, that's intense.
Yeah. The workforce is now legally informed of the specific risk that their employer put them in. This is Section 28 of the Act, by the way.
It just seems like a massive, immediate disruption to a business. Naturally, a company facing a complete shutdown of a core operation is going to push back, right?
Right.
Do they have any recourse to lift that quarantine?
Well, there is a recourse, but it is an incredibly tight legal window. A business has a strict 21-day period to appeal an enforcement or a prohibition notice to the employment tribunals.
21 days. Okay.
But, and this is the kicker, the law is designed to prioritize physical safety over legal wrangling. So if a business appeals a prohibition notice, that notice remains fully active during the entire appeal process.
Wait, really? Meaning you cannot just file an appeal to buy yourself time to keep working while the lawyers argue about it?
Nope. The operation stays shut down. The only way it resumes is if the tribunal explicitly finds in favor of the business.
Which probably isn't very common.
It's not. More commonly, the hazard is completely fixed to the satisfaction of the enforcing officer, and then they officially suspend the notice. So the mechanism forces immediate, undeniable compliance.
That transition from the chaos of the factory floor to the cold reality of a formal legal lockdown is jarring. But, I mean, it's not just about halting an operation, right? It's about identifying the specific mechanical failures that justify that lockdown.
Exactly. And when you look at the physical breaches inspectors document, some of them genuinely challenge basic common sense.
Oh, for sure. They reveal this massive gap between a company's glossy written safety policy and the lived reality on the shop floor. The most vivid one for me is the ladder repair.
Oh, the wire and string.
Yes. An inspector finds a damaged A-frame ladder actively being used on site, and the center's support, the crucial component keeping it from collapsing, has literally been replaced with a piece of wire and string.
I mean, you can't make this up.
It's absurd.
It really is. And this is where we move from just spotting a physical hazard to identifying a specific legal breach. Under the provision and use of work equipment regulations, which is commonly known as PURE, repairing a structural piece of equipment with wire is a massive, clear violation.
Yeah, Regulation 5, right?
Exactly. The mechanism of PURE requires that all repairs to work equipment must be validated against the manufacturer's specifications.
Well, I am fairly confident no industrial ladder manufacturer includes wire and string in their structural repair manual.
Yeah, I think that's safe to say. But the logic behind the regulation is what really matters here. If you cannot validate the suitability of the equipment after a repair, it introduces a rogue variable into the workplace.
A rogue variable, I like that.
Yeah, because the law dictates a binary choice. You either ensure the integrity isn't compromised, or you remove it from use entirely. There is zero middle ground for improvised MacGyver-style fixes.
Right. And the threats inspectors document aren't just on the ground either. There are hazards looming above, too. There are instances in the sources of heavy boxes of stock being dangerously stacked on a mezzanine level and out in a yard, literally towering over walkways.
Which triggers a completely different set of legal mechanisms, specifically the work at height regulations from 2005. The law mandates that suitable and effective measures must be taken to prevent any person from being struck by a falling object that's likely to cause injury.
So it's Regulation 10 then?
Yes. Inspectors frequently have to formally demand that irregular-shaped items not be stacked directly on top of each other, and that stock on a shop floor shouldn't exceed head height.
There's another wild detail about a false ceiling above an office space.
Oh, yeah, that one.
It was reasonably foreseeable that maintenance staff would need to access the area above it. But at the time of the inspection, nobody in the company could verify if the structure was actually sound enough to hold a human being's weight.
Which is terrifying.
Right.
So the inspector required the company to conduct a structural integrity test before anyone was ever allowed up there again.
Okay, let me push back on this a bit, though, because it feels like we are dealing with absolute basics here. Don't fix a ladder with string. Don't walk on a ceiling that might cave in. Don't build a Jenga tower of heavy boxes. In a post-incident investigation, how does an inspector legally prove a company lacked foresight?
What do you mean?
Well, it seems difficult to prove a negative, right? To prove what a manager didn't anticipate. How do they prove a duty holder failed that standard of doing what is, so far as is reasonably practicable?
That is the crux of the entire investigation process, actually. And the way the law structures that foresight is fascinating. It relies on a concept called the hierarchy of control.
The hierarchy of control.
Yeah, the law does not expect absolute perfection, but it expects a highly structured approach to risk. For example, those work at height regulations we just talked about, they require an employer to give collective protection measures priority over personal protection measures.
Okay, walk us through how that plays out in reality.
Okay, so it means you cannot just hand a worker a hard hat, point to a badly stacked mezzanine, and tell them to watch out for falling boxes.
Right, because the hard hat is personal protection.
Exactly. It's the last line of defense. The law requires you to implement collective protection first. So, you install a tow board or a guardrail on the mezzanine, you change the physical stacking procedure entirely, you basically alter the working conditions at the source.
Oh, I see.
Yeah, if an inspector sees you relying on a hard hat when a guardrail was totally possible, they have pinpointed the exact moment your foresight failed. You chose the cheaper, less effective personal protection over the systemic collective protection.
And that concept of reasonably practicable is a sliding scale, isn't it?
It is, yeah. It balances the quantum of risk against the cost and effort of averting it. So if a massive multinational corporation with endless resources fails to install a guardrail, they will face a much harsher judgment than, say, a tiny family-run shop facing a highly obscure, unlikely hazard.
Right, that makes sense.
But a wire and string ladder fails the test of reasonably practicable at literally every conceivable level of business.
Yeah, clearly. But it's not just the physical environment, the ladders and ceilings, that triggers a prosecution. The law considers the invisible administrative environment just as rigorously, which really brings us to the shift from the factory floor to the interrogation room and the immense weight of the paperwork trail.
Yeah, because when a physical failure happens, it usually points to a deeper systemic failure. And that is exactly what inspectors are hunting for when they bring duty holders in for formal questioning.
Let's talk about that questioning because, from what I've read, this isn't a casual chat over coffee.
Oh, no, not at all. This is typically a PACE interview. PACE stands for the Police and Criminal Evidence Act.
So it's basically a police interrogation.
It's identical. It is a formal, recorded interview under caution, exactly like how a police detective interrogates a criminal suspect. The duty holder is read their rights, and they are acutely aware that anything they say can and will be used as evidence in a criminal prosecution against them or their company.
In that high-pressure scenario, you can easily imagine a terrified manager trying to hide behind corporate bureaucracy. They'd probably point to a binder on a dusty shelf and say, "Look, we have a safety policy. We trained our people."
And that is exactly where the inspector uses the company's own paperwork to dismantle their defense.
Wow.
Yeah, the physical evidence from the site, the string on the ladder, the missing guardrail, is directly cross-referenced against their written risk assessments.
Which leads to the illusion of the tick box culture. There was a brilliant example of this in the investigations. An inspector reviews a brandless site-specific risk assessment. The employees had a form, but they only ticked the column for the likelihood of an accident.
Right.
They completely failed to estimate the actual severity of the risk, and they completely ignored significant pieces of machinery entirely, like a heavy carpet manipulator.
Whatever that is, it sounds heavy, but yeah, that document is a literal legal trap that the company built for itself.
There is a dangerous irony here, though. In a PACE interview, wouldn't a manager argue that having a paperwork on file proves they at least tried? Like, isn't a flawed risk assessment better than having no document at all?
Actually, forensically speaking, a flawed document is often much worse than no document at all.
Wait, really? How does that work?
Well, under the Management of Health and Safety at Work regulations, an employer must carry out a suitable and sufficient assessment of the risks. That's Regulation 3.
Okay. Suitable and sufficient.
Right. So a form with a single tick mark that ignores major machinery is practically a signed confession. It proves that the employer recognized the legal need to assess the area, they physically looked at the workspace, and they still failed to identify totally obvious hazards.
Oh, wow. So it proves they knew they had to do it, but did it terribly.
Exactly. It proves the negligence wasn't just a simple oversight, it was documented incompetence.
It proves a fatal disconnect between a written policy and site reality. So what happens when an accident actually occurs, but maybe it wasn't fatal, just a serious injury? How strict is the reporting trail?
The trail is relentless. The regulations require employers to investigate the circumstances of every accident. They are legally obligated to keep a readily accessible record, usually an accident book or a digital log, of any accident causing personal injury.
And how long do they have to keep that for?
Crucially, they must preserve that record for at least 3 years from the date of the entry.
3 years. So an inspector walking in today can audit your history of negligence going back 36 months, looking for a pattern of ignored warnings.
Absolutely. And they use incredibly heavy-handed information gathering powers to get it. When an investigation is underway, inspectors issue formal demands for information regarding the causes of incidents and remedial actions.
I assume they don't give you much time either.
No, they often give the company a rigid 14-day deadline to comply.
I can imagine a company panicking, realizing their accident logs are just full of unresolved hazards and trying to stall. Could a clever lawyer argue, "Well, we'd love to hand over the employee accident logs, but privacy laws prevent us from sharing personal medical data"?
A lawyer might try that, sure. But the law anticipates that exact defense. The Data Protection Act contains a specific, built-in exemption for information relating to the protection of persons against risks to their health and safety at work.
So privacy laws do not shield a company from a health and safety investigation at all.
Not even a little bit. The legal shield just evaporates. And the inspector closes that loop with a massive immediate threat.
What's the threat?
Refusing to provide the requested information or failing to meet that 14-day deadline is not just considered unhelpful. It is officially classified as obstruction. And obstruction is a direct criminal offense under Section 33(1) of the Health and Safety at Work Act.
That changes the temperature of the room entirely. They bypass your privacy shields, demand your 3-year history, and turn a civil stalling tactic into an immediate criminal charge.
It completely corners the duty holder. You either hand over the paperwork that proves your negligence, or you face prosecution for hiding it.
But the reach of this law goes even further, doesn't it? It's not just the physical equipment, the ladders and ceilings, or even the paperwork that can trigger a prosecution. The law considers the invisible environment and systemic threats just as rigorously.
It really does. This is where we see the true breadth of an employer's duty. It is not just about what you can touch. It is about foreseeable systems of work.
There is a detail in the regulatory records about an armed robbery at a retail premises, and the inspector actually flags this as a health and safety breach.
Yeah, that's a fascinating one.
Now, the logic there feels a bit stretched at first glance. How is an employer legally responsible for the violent actions of an independent criminal? That sounds entirely like a police matter.
Well, it is a police matter, obviously, but it is simultaneously a safety breach. The 1974 Act dictates that you must ensure your employees are safe from foreseeable risks.
Okay, foreseeable is the key word there.
Right. If you operate a business where an armed robbery is a known foreseeable hazard, like a late-night retail shop, a bank, or a pharmacy, you cannot just hope for the best.
You can't just cross your fingers.
Exactly. You must have a documented system in place for effective planning, control, and preventative measures regarding violence to your staff.
So if you haven't done a risk assessment for the possibility of your staff being robbed, and it actually happens, you are liable for failing to protect them, regardless of the robber's actions.
Yes. The failure to have a safe system of work is the prosecutable offense, not the robbery itself. The employer isn't prosecuted for the crime. They are prosecuted for putting their employee in a totally vulnerable position without a plan.
This expands the definition of workplace safety immensely. And we see this applied to modern invisible threats, too. There are instances in the sources of improvement notices being threatened against businesses for failing to implement COVID secure control measures during the pandemic.
Because failing to adequately control the risks arising from a work activity includes viral pandemics, the law remains exactly the same. Identify the foreseeable risk, implement control measures, and document them.
Right.
Inspectors were demanding risk assessments, photos of control measures, and proper signage by specific dates, all under threat of formal legal action.
And it applies to older hidden threats like asbestos, too.
Oh, for sure. Under the control of asbestos regulations from 2012, we see companies getting caught out not because they didn't know asbestos was there, but because they just start paying attention to it.
What do you mean?
Well, an employer might have an asbestos survey done, which is the first step. But if they fail to regularly inspect those asbestos-containing materials for deterioration over the years, they are in breach.
Yeah.
You have to manage the invisible threat continuously, not just identify it once and put the report in a drawer.
It seems like they can catch you on the biggest systemic issues, like an armed robbery, down to the absolute smallest granular details. Like, there's a mention of a site having absolutely no appointed person to take charge of first aid, and not even a basic first aid box on the premises.
Which is a direct violation of the 1981 Health and Safety First Aid Regulations. A missing bandage seems incredibly minor compared to, say, asbestos or a collapsing ceiling, but legally it carries massive weight.
Because it shows a lack of care.
Exactly. What constitutes adequate first aid obviously depends on the specific workplace, but having zero provision is a guaranteed, undeniable breach.
So putting this all together, whether it is a virus, an armed robber, an uninspected asbestos tile, or a missing first aid box, what is the underlying thread the inspectors are actually looking for?
They are looking for the presence or absence of a positive safety culture. That exact phrase is central to these investigations.
A positive safety culture.
Yeah. It must be recognized and driven at all levels within the organization, from the boardroom right down to the shop floor. It means safety isn't just a reaction after someone gets hurt or after a council officer freezes your site. It has to be a proactive, documented, and lived reality.
And when a case finally moves toward prosecution, that culture is really what is put on trial.
Ultimately, the final criteria for a council's legal team is determining if a case meets the public interest for a trial. If an investigation reveals a demonstrated lack of a safety culture, if they find the wire and string ladder, the tick box risk assessment, and the missing first aid kit, the decision to prosecute becomes very, very easy.
Because they have the forensic proof of systemic negligence.
Exactly. And with sentencing guidelines continuing to evolve, especially the 2026 updates, we see penalties scaling dramatically based on a company's total financial turnover.
So it's not just a flat fine anymore.
No, the financial and reputational consequences for these fatal failings are designed to be entirely ruinous for negligent businesses. The net is wide, the mesh is very fine, and the penalties are meant to deter the entire industry.
This has been an incredibly eye-opening journey. To summarize, a workplace inspection is not just a friendly walkthrough to spot trips and falls. It is a meticulous legal mechanism designed to capture negligence in real time.
It absolutely is.
We've seen how inspectors establish immediate control by freezing a site. We've seen how they trace the physical failure of a broken ladder straight into the interrogation room, and how a flawed piece of paperwork essentially becomes a signed confession of incompetence.
And if we connect this back to you listening right now, it really changes how you should view your own environment. Every policy you read, every training signature you provide, and every single warning sign in your workplace is a crucial piece of a massive legal puzzle.
Yeah, that's a great way to put it.
It's a puzzle designed to keep you safe and to hold those in charge fiercely accountable if they fail that duty.
Next time you look at that first aid box on the wall or fill out a routine risk assessment, ask yourself this. As remote work and AI continue to blur the lines of traditional employment, how will the law adapt? When your workplace is your own living room and your system of work is managed by an algorithm, how will an inspector of the future define your employer's duty to keep you safe?